We should know that when the statutory company will come under the basis of incorporation. These companies are incorporated under the provisions of Companies Act of 2013. A company that has the liability of its members are limited by the memorandum. Every public company should have at least 3 members as the board of directors compulsorily as per section 149 subclause 1. Hello my dear students, welcome to BCom second sem unit 1 sessions 2 of company law. I'm Professor Rajesh LR from Department of Commerce and Management, Vidhyaashram First Grade College of Commerce, Temple of Excellence, MYSURU. In our previous session, we have discussed about what is a company, how the company came into existence, what were the features of the company, and even the features of Companies Act of 2013 after modified, what are the changes, provisions they have made for the Act 2013. And even we have learned in our session about the company structure, how it will be made based on the line of business selected by the company. In this today's session, we're going to discuss about entire concept of the types of company in that one on the basis of incorporation, on the basis of liability, or on the basis of miscellaneous and other part here. In our present concept, we are going to discuss about on the basis of incorporation. When the companies are classified into basis of incorporation, the first company here is statutory company. Statutory companies are always called as a public company, brought into existence by the special act of the parliament. That's saying that all these organizations are under the special act of the parliament. The act defines the powers and functions, rules and regulations. The act is going to define all the rules and regulations. Either it may be for activities of the company, appointment of any person for the company, or its functioning in the market. Everything will be based on the act. It has prescribed in such a way that how they have to work and how they have to perform in the organization, and its relation with the government departments, how it has to have the relationship with the government departments in certain business activities. For example, the statutory corporations are Reserve Bank of India, State Bank of India, Life Insurance Corporation of India, Unit Trust of India, Employees State Insurance Corporation, Oil and Gas Corporation. These are the better examples to know that what are statutory companies and how they are working in the market for the betterment of the society as well as for the government here. We should know that the statutory company will come under the basis of incorporation. The second one we have on the basis of incorporation, the second company is called registered company. The name itself says that these companies are incorporated under the provisions of Companies Act of 2013. They're saying that all the companies which are registered as per the Companies Act of 2013 or previous to the 2013 Act, getting themselves registered with the authority, that is register of companies. They are saying that the companies which are registered themselves with the ROC by submitting all the required documents and proving themselves, they are going to be the registered organization in the market. The next one we have here, after the incorporation, the next part comes here on the basis of liability. Liability is nothing but the debts related to the company, how the company have the debts and how it has to control all the debts of the organization. If we say that like for example, the company is not restricted to its liability, the board of directors or the company may raise the debts how much ever they want, where it is not necessary for the organization, where it may be misused. For that reason, we have on the basis of liability, the first company will come here on the basis of limited by shares. The first under liability, we have companies which are limited by shares. A company that has the liability of its members are limited by the memorandum. They're saying that when the liability of all the members of the company are limited by the memorandum in the MOA. At the time of preparing MOA, they restrict that one. What is the number of shares are held by the members? Equal to that one, the members have the right to raise the liability, or else they don't have the right to raise the liability above the shares whatever they have purchased here. If any unpaid on the shares respective held by them is termed as the company limited by shares, the liability can be enforced. The liability can be enforced during existence of the company as well as during the winding up of the company. They're saying that the liability of the company are enforced during existing, means they're saying that one at the time of having business in the market, what is the liability are there and what are the unpaid shares are there, how to raise the amount on the unpaid shares, and even at the time of winding up, if there is any shares which has been not called the money, the liquidator has the right to call for the money at the time of liquidation to make the payment for the debts. For example, if a shareholder who has paid 75 on a share face value of 100, the face value of the share is 100, I have paid here 75, still I have a due of 25 rupees. What is the face value of the share here? It is the face value of the share is 100 rupees, where I have paid 75 rupees and still I have not paid 25. At the time of liquidation, the liquidator has a right to collect this 25 rupees per share from me, that is a shareholder, whatever the number of shares held by him. This amount can be used for the payment of the debts here. The companies limited by shares are far most common and maybe either public or private company. Company limited by shares, it may be both. Either it may be a public company or a private company. It is not necessary that it should be a government company. It may be public limited company or private limited company. On the basis of liability, the second one we have here, companies limited by guarantee. Means they are saying that one, we are going to give some assurance for the shareholders or the investors of the company. Company limited by guarantee is a company that has liability of its members limited to such amount as the members may respectively undertaken by the memorandum. Means they are saying that one, the restrictions are made here as per the MOA, and the duty of the members is to not to raise the debts. They have to give the guarantee in case of liquidation. In case of liquidation of the company, if the debts are not fulfilled with the assets of the company, we are here to clear the debts of the company. In case of such companies, the liability of its members is limited to the amount of guarantee undertaken by them. The members of such company are placed in a position of guarantors of the company debts up to the agreed amount. They're saying that one, they are going to be liable for the certain amount, whatever they agreed that one at the time of signing the MOA, that amount will be collected in case of liquidation. Clubs, for example, companies limited by guarantees may be clubs, trade associations, research associations, societies for promoting various objects of the guaranteed company. Here, for example, which are the guarantee company, means we can have the club, sports club or any type of clubs, whatever we have in the market. Next one, on the basis of liability, the third company we have here, unlimited liability. The name itself says that one, there is no limits for the liability of the company. A company not having limit on the liability of its members is termed as unlimited company. As I said that one, the company has no limitation on the liability of the members. Here the members are liable for the company's debts in proportion to their irrespective interest in the company. They're saying that one, if I'm the director of the company or member of the company, based on the interest, whether I have participated in all the meetings or not, whether I'm visiting the organization on certain intervals or not, if in case of liquidation or at the time when the debts are more here, even I am liable for the debts whatever the company has raised for the purpose of business activities. Such companies may or may not have share capital. They may have either a public or a private company. They're saying that when the company's shares may not be there to clear here, and even these companies also may be a public company or a private company. We should understand clearly that when unlimited liability corporations or companies are maybe a public limited company or a private limited company. The first type of company after on the basis of incorporation and on the basis of liability on the miscellaneous part, the first company we are going to discuss here will be public company. And we were discussing in our liability on the basis of liability or on the basis of incorporation, we have termed certain company, certain like as public company as well as private company. Now we are going to discuss clearly which company is called public company, how they are going to be called as a public company, and what are the rules and regulations are there. Under Section 2, Subclause 71, under Section 2, Subclause 71, the Companies Act of 2013, under Section 2, Subclause 71, the Companies Act of 2013 says that when a public company means a company which is not a private company. The companies which are not private limited companies are called as a public limited company. Under Section 3, Subclause 1 of the Companies Act 2013, a public company may be formed for any lawful purpose by 7 or more persons. The minimum number of persons required to form a public company are 7, and there is no limitation for maximum numbers. There is no limit for the numbers maximum here. For minimum, we have 7 members. Section 149(1) of the Companies Act 2013, every public company shall have minimum 3 directors in its board. They are saying that every public company should have at least 3 members as the board of directors compulsorily as per Section 149 Subclause 1. Section 4, Subclause 1A of the Companies Act 2013, a public company is required to add words limited at the end of the company's name. They're saying that one at the end of the company. For example, a limited company. A limited company. They're saying that one we have to use the word limited after the name of the company. Like for example, State Bank of India, State Bank of India Limited. Like we have to have the name of the company or any other things like this. The company should present the limited at the end of the name of the company as per Section 4, Subclause 1 of Companies Act 2013. In public company, the minimum paid up capital of 5 lakh rupees. They are saying that one for any public company, the minimum amount of paid up capital should be 5 lakh rupees. They're saying clearly, make out this helps you for people. If they ask for difference between public company and private company, we can use the sentence for the differences to write and secure good marks here. The second one, the public company as limited at the end of its name. Like I've given example here, ABC Limited Company. Every public company should have to mention limited at the end of its name. And this is the point which helps you to write the differences. The minimum number of members needed to form a public company is at least 7 members. For any public company, we require 7 members to form. Minimum is 7 and maximum, there is no restriction. The public company have no restrictions on maximum number of members. In any public company, there is no restrictions to become the number of members here to have. It can have any number of members to form the business as well as to run the business activities in the market. The public company is free to transfer the shares of its company from one person to another. This is the next difference what we can keep in our mind at the time of differentiation between public company and private company. They are saying that public company has the free. The company has the free to transfer the shares of the company, and they don't have any restrictions at the time of transferring shares of the company from one person to other person. But in the private company, we have certain restrictions. The next point we have here, a public company must have three directors at least. Already I've said to people in the definition, every public company should have three directors to manage, to lead affairs of the company. They're saying that one, that three directors who have been selected and who have to be every public company to take care of the business activities, either to supervise or to monitor or to lead or to take certain decisions, whatever the business activities are there in the market. The next point we have here, a public company can commence its business. A public company can commence its business only after receiving certificate of incorporation and certificate of commencement of business. It can't start its business as soon as it receives the certificate of incorporation. It has to receive both the certificates, certificate of incorporation as well as commencement of business certificate. Then only they can start the business activities. But for private company, it is not like that. So we can use this point for the differentiation. Next, the public company can issue a prospectus. It's free to invite public for subscription of its shares. The public company has a right to issue the prospectus freely and inviting the public to subscribe the shares. But whereas private companies doesn't have the right here to issue the prospectus. This is the major difference what we can write if they ask difference between public company and private company. The public company cannot be able to allot shares before the minimum subscription of shares is completed. They're saying that one, every public company has to collect or receive minimum number of shares which has been issued to the public here. For example, if I have issued 5,000 shares to the public here, at least minimum means here, for example, 1,500 shares we have made as a minimum subscription. So I have to receive minimum subscription of 1,500 shares. Then only I can allot the shares to the people who have applied for the shares in the company here. If I have not received, I means here a public company. If the company has not received 1,500 shares application, then it cannot allot any shares to the people who have applied for the shares of a company. In today's session, we have learned about the companies on the basis of incorporation, on the basis of liability, and public company and its functions, or the main points of the public company we have discussed it, which will support you people to write about the public company easily and understand that concept of the public company. And even it is better for you people to know these points for the difference between the private company and public company of the organization, to write that one and score good marks here. Thank you, my dear students. Have a good day.